Can I still sue if I was partially at fault? So the short answer for this is yes, you can. It's called comparative negligence, and the law here in California takes care of that for you. The longer answer is that it can be a little bit confusing and it can be different for personal injury cases and medical malpractice cases. I'm Brian Finley. I practice with Finley Law. We handle both personal injury and medical malpractice cases here in San Diego and throughout California. So with personal injury cases, the legal term is comparative negligence. And comparative negligence means that if you were to sue someone, you get all the way to trial, and we would figure out what your damages are for the injury that you had. There may be an offset applied for whatever percentage fault that the jury finds that you were responsible for. So say there's a $100,000 judgment for your injury, and the jury finds that you were actually 30% at fault. The person that hit you with their car or built the defective sidewalk was 70% at fault. You would get a total award of $70,000 because your 30% is going to be taken off of that jury award for you. It gets confusing for people a little bit because the law in California used to be different. There used to be a concept called contributory negligence, which meant if you were even 1% at fault, you could not sue somebody, or you could not win in a lawsuit against someone for whatever injury they may have caused, even if they were 99% at fault. That's not the law anymore here in California. I break it up for personal injury and medical malpractice because there's an important point to know in medical malpractice. So if you were injured by a medical provider, say that a surgeon performed some surgery negligently on you, and let's say there was some follow-up care that surgeon recommended that you come in and get. If you decided not to go through with that follow-up care and that ended up causing your injury or made your injury worse, there's going to be a difficult determination that's going to be made where maybe you're not allowed to recover anything at all in the medical malpractice context because of your failure to follow reasonable medical advice given to you by your physician. That's an affirmative defense at trial for California medical malpractice cases. It's something you generally wouldn't get to until you're well along in the process. It doesn't mean you can't make a claim for medical malpractice, even if you think you might have missed an appointment or two after your injury. So if you'd like to consult with us about a personal injury case or a medical malpractice case and find out where you fall along that spectrum, please give us a call, Finley Law.